Yeah, hello and welcome to the podcast on the impact of dual use technology on human rights and minority rights. It's such an honor for us to have with us Professor Guimarães all the way from Brazil, to discuss this uh, topic. He is an expert in technology and human rights to discuss the complex and concerning issue of dual use technology and impact on uh, its impact on human rights and minority. Thank you so much, Professor, once again for taking out your time. So I would request you to introduce yourself.
Okay, good evening and good morning, dear colleagues from all over the world who are following us by by the SARIM Institute, the South Asia Research Institute for Minorities, based in Pakistan. So first of all, I'd like to present my gratitude to my dear colleague, Furqan Ahmed, who's also a member of the RC26 for the International Association of Political Science. So I'm talking to you directly from Brazil. I'm based in the northeast of Brazil. I'm a criminal prosecutor and also law professor and geopolitics professor for the Federal University in the state of Maranhão and for the School of Law in Vitória, based in southeast of Brazil. And I have the pleasure and honor to serve as a consultant and legal assistant for different international institutions and scientific associations, such as the IPSA, the International Association of Constitutional Law, and member as well of the International Law Society, the European Society for International Law, the International Association of Criminal Law, and the International Criminology Society. Now, regarding to the topic that I was invited to share some ideas about, which is the dual use of technology in the constraints, possible constraints against human rights minorities. It's always very good that we can work since from the very beginning about the concept of dual use technology. What does it mean? Actually, it constantly refers to technology that can be used for both peaceful and military applications. It can also encompass technologies that have been both beneficial uses and potential for misuse in ways that could harm human rights or minority rights. While I can access currently the last fact finds about the misuse of that technology, we can certainly give some examples of episodes that have happened from the last decade. So I'd like to illustrate the complex interplay between technological advancement and the protection of fundamental rights. How do we use a technology, dear Furqan, can be used or misused regarding the protection or the disenfranchisement of minority rights? For example, internet surveillance tools, facial recognition technology, mobile phone tracking, social media monitoring tools, censorship technologies and tools, export of surveillance technologies, drones and aerial surveillance, predictive policing tools, biometric databases, artificial intelligence and algorithmic decision-making, stingray devices such MSI catchers that basically are used by law enforcement to intercept mobile phone communications. And these devices can be deployed without clear legal frameworks, for example. And what would be the risks for the disenfranchisement of minority rights? For example, risking privacy and potentially targeting activities and minority groups disproportionately. Another example that dual technology could be employed or deployed against is the digital currency and financial surveillance, internet shutdowns, export controls and cybersecurity technologies, deepfake technology. These are examples that underscore the importance of establishing robust legal and ethical frameworks to govern the development, export, the use of dual-use technologies, ensuring they serve to advance human rights rather than undermine them. So briefly speaking, that's a general, a broad idea of dual technology. Of course, it should be advisable that we can also approach the conception of critical technology. What would be critical technology? For instance, D3 printers can fall into the category of dual-use technology and critical technology. When we think about the arms trafficking, so some components of arms can be produced using 3D printers. Meanwhile, would be not easy for the borders control policy to get acquainted with the trafficking and the use of those kind of arms to use different conflicts or to unbalance political biases in some countries. Furqan, I give you the floor.
Thank you so much, Professor Cassius. You have briefly informed us. I mean, these were some of the things that I never had the idea that exist in this current age, and I'm actually surprised that we are being, and I'm sure it has been practiced widely against some of the human rights and minority rights defenders as well. And by and large, you have categorically explained about the tools, the elements, that how these technologies can be used or even manipulated in this day and age. So thank you so much for brief introduction about the topic. We will now move on to our question answer session. You have somehow covered my first question, which is basically how do you think dual use technology has influenced the way human rights and minority rights are perceived and protected in the digital age? You talked about some of the issues. Now it's about some of the solution part, I guess.
Yeah, many thanks for your question. So, for example, maybe we could enforce the policies internally in our countries, in our societies, but of course, it's very important that our countries, our governments, can be at the same page in terms of the idea of a human right protection system. Having said that, we shall share mutual legal correspondence in terms of human rights framework and institutional design, aiming to protect you, me, my society, your society, and the very legitimate possibility that all of us can be part of the civilizational process that technology carries with it. So, in that regard, it's very important that our governments, our societies, our parliaments, all of us can, at the same time, in this very historic moment, we can share common understanding and concern and institutional designs to be implemented in our societies in order to assure the ethical use of technology, in order to assure that all men and women in our society can be granted access, can be granted the knowledge of the use and the possible misuse of technologies. Because if I handle my mobile phone, I can use these apparatus to achieve very important goals in my day-by-day activities. But also mobile phones can be used to enforce the disenfranchisement of human rights and to fragilize the minority rights. How, Professor Chai? Well, if surveillance is used with the misuse of mobile technologies, despite this very important tool to update us in our day needs, the mobile phone and technology can also be used against us in terms of disenfranchising privacy against the law. Now, Furqan, I think that we could improve this mutual legal correspondence if we can share, for instance, a very new initiative carried by the United Nations entitled the Protecting Minority Rights, a Practical Guide to Developing Comprehensive Anti-Discrimination Legislation. So, of course, in this current moment in our human history, all our societies, Brazilian society, Pakistani society, American society, French society, we are governed according to the principle of the rule of law. And what does it mean? It means that we have chosen the rule of law as a social system to stable and stabilize our social expectations about the possibility of a good life, of the possibility to protect our human dignity. Now, the rule of law institutional design is an outcome of political choices. So first of all, the Brazilian government, the Pakistani government, the American government, the French government, all these governments, they have to decide to pursue legitimate goals abridged by the very concept of fundamental rights and have as the basis of this idea of fundamental rights, the human dignity. The human dignity shall be the same mutual legal correspondence for us in Brazil, for you in Pakistan, for the Americans to themselves, for the French people themselves. So regarding this possibility to enforce the features and the institutional designs aiming to protect minority rights, first of all, we should get rid of legislation and rules that cannot be complied with the very idea of equals and the protection of freedoms in our society. Because we have to understand that the coefficient of the different is the balance of equality. We are equals because all of us, we are different, each from another one. So with this concept, we have to understand as well that the equality is an undeniable element that constitutes legitimately the understanding of freedom, of civil liberties. So I think, and I do agree with much of this content of this practical guide, that we have to achieve a consensus on the need to adopt comprehensive anti-discrimination law. We have to get a social consensus about the understanding of human dignity. We have to enforce our regional and national law features and institutions regarding the first commitment that shall be to protect the human right and the human dignity, despite your political ideology. And secondly, we have to achieve another consensus, levelly speaking, that your political ideology shall be committed with the protection of the difference. So beyond that, we should implement some constitutional remedies or writs of mandamus to protect the freedom of mobility, to protect the freedom of expression, but of course the freedom of expression at the same time, we have to implement features about the accountability, because democracy requires, of course, not only absolute freedom, but democracy requests the collective commitment with the idea of the common good.
Thank you so much. There is a question coming up. A follow-up question in terms of you talked about legitimization. When you talk about being its system being legal or comply with the use of technology and something and things like that. But do you also think that there are people or there are decision makers who are sitting in the parliament or who are sitting in the benches of legal system as well? Do you think they are uh, tech savvy or digitally equipped in a way to comprehend the let's say the consequences uh, or the system which digital use comes into play? But do you really think are they really well informed in terms of how digital use technology or dual use technology are used? So there are certain politicians, in Congress as well. Then there was a hearing going on against Mark Zuckerberg, and there were some questions, raised. Some common question, but it seemed like that it lacked technical aspirations of it. So do you think there is a need of build the capacity of those decision makers or lawmakers before talk about or bring the legal aspect of the legitimization of the dual use technology? It's just a assumption from my end.
Many thanks. Yeah, many thanks. As you pose your question, I remind myself some examples that, departing from these facts finds, we can elaborate some concerns and some possible reflections, critical ones. So recently, it was under investigation in Brazil that our former president, Bolsonaro, he institutionalized a site, dark agents, to monitor, to surveil political opponents. And also, investigations currently point that he used this apparatus of technology monitoring mobile phones network, surveillance illegitimately, illegally. So he also monitored some of his own political side-by-side colleagues. So the technology is there. He is the chair of the branch. How he has used and accessed the power that was granted to him by the vote in our democracy. I can give you another example that a couple of years, November 21st, 2022, the Paris Court of Appeal confirmed the indictment of surveillance company Amesis, AMESYS, and its executives for complicity in torture in Libya, while canceling the indictment of 2 employees, because the employees themselves, they were doing what has been told them to do. So the court's decision is seen as a positive development in holding surveillance companies accountable for human rights violations. And right now in Brazil, what's being done is to get accountable the former president because of the misuse of the power, the misuse of the technology, the misuse of the national agents of intelligence. We have in Brazil this national intelligence agents, which is named ABIN. And it's being said by the investigation so far that he has to survey politically. I would like to quote a little short fragment of Clemens Batacht, and Emmanuel Dadou, lawyers for the International Federation for Human Rights. And I quote their words. The confirmation of these indictments related to the French case, which occurred almost 10 years. It was in 2011, Furqan. 10 years after the opening of the judicial investigation is a source of hope. But why it's a source of hope? It's now clear that surveillance companies can no longer hide behind an alleged ignorance of potentially devastating impacts of civilian populations. Close the quotes. So we have to agree in the end of the day that technology is an open source of push us forward in our civilizational process, but also it comprises many risks that so far we haven't opened what I could say the Pandora boxes, because technology carries many unavoidable, undeniable possibilities that we can achieve other levels of human dignity protection, but also it can aggravate our expectations for the human right protections. It's like a Pandora boxes, if you understand me. So I'd like to share with you another example that June 2022, the ransomware group called Playgroup violated 300 victims, including victims in South America, impacted in a wide range of businesses and critical infrastructures, not only in South America, but in North America and in Europe. Around 300 companies worldwide were targeted in breaches between June 2022 and October of last year, including, according to investigations carried by the FBI, the alert was issued by the Federal Bureau of Investigation in the United States in collaboration with the U.S. Cybersecurity and Infrastructure Security Agency, CICSA, and Australian Signals Directorate, Australian Cybersecurity Centre. So these are some examples how technology can be misused in order, of course, to unbalance democratical process. Recently, in 2021, before the last general elections in Brazil, that President Lula was again elected for this term at the presidential office. We have no doubt how the disinformation industry was pulled the strings to mislead, to taint the electoral process in Brazil, damaging our democracy. So the risks we have in all these kind of levels when we check the variables related to geopolitical features, meaning economy, national defense, political force, psychosocial features, and the transfer and achievements of science and technology. So far, much of the colonial tools to colonize the peripheral, the so-called peripheral world, these ancient tools, they have been changed to the metaphorical figures of intellectual property, of transfer of technology. So right now, the plantation is not in the fields themselves mostly, but we live in this relation, social relation, international relation, abridged by a different functioning of these colonizing architecture. And the most sensitive one is the transfer of technology. Because we in the peripheral world, we are paying off for the most of the good life that the owners of the technology they have been living.
Thank you so much. I'm skipping our question number two because you have majority of your answers or the explanation has been given by you when I was about to ask you about the positive and negative purposes of relation in relation to human rights when we talk about dual use technology. So you have categorically given us at least two, three major examples of this kind. I'm moving on to our third question. You talk about security and privacy in your introductory lecture. How do you believe the balance between security and privacy can be maintained in the context of dual-use technology to ensure that the rights of individuals are not infringed upon? There you go.
Okay, we have to ensure and to implement and to increase the levels of social control, transparency, accountability, and integrity. So without these elements to put some patterns for our governments and for our democratic institutions, in the end of the day, if we don't have transparency, if we don't have the possibility of social participation, our democracy, it's very weak. So if you cannot hold accountable those of us who are representing us in this architecture of democratic institutions, how can we say that we are free and equal people? We are not. So that's the inner and sensitive question as an undeniable condition to establish democratic institutions themselves. So I would say that we have to enforce accountability, we have to enforce transparency, and we have to enforce and to revigorate the dialogue between civil society organizations, government agencies, and somehow to establish the open access. Of course, there are some national security issues that shall be comply with the different architecture institutionalized to legitimate the results and the proceedings. But we have to enforce proceedings regarding to transparency, accountability, and the independence of judicial power.
Thank you so much, Professor Cassius, for your response. In what ways do you think the international community, including organizations like UN, United Nations, can play a role in regulating the use of dual-use technology to protect human rights and minority rights issues, as you just talked about now, that there is a need of, I would say, digital democracy in terms of being balanced. So, yeah, please proceed with your.
Yeah, all of us, we are constrained by some international principles, such as the sovereign principle, the auto-determination principle, and of course, the principle of no intervention by violence. But having said so, of course, the United Nations and the international organisms as institutions, I think that they can comply with their role, firstly, enforcing the mutual legal correspondence. So we have to enforce the international legal cooperation. We have to speak the same language and have the shared understanding about what is ethical and what is not ethical, about what is legitimate to carry on in terms of institutional designs to protect the human rights and what is not. For instance, we have to speak the same language in terms of understanding what is discriminated law and what is anti-discriminate measures to filter the law in order to comply the law with the understanding of human rights protection. So I think that your question is about the international community. Mostly what we can do is a pedagogical activity to share this understanding. And of course, in terms of international relationship, what is most efficient is the economic sanctions that can be applied in cases and circumstances that human rights protections are not implemented. But yet, we have perceived much of incoherence regarding to international community. For example, because in some regions in the world, some activities are completely said that they are not legitimate. In other circumstances, we have witnessed that some episodes in terms of international aggression, they could be justified. So we should be more coherent about the sharing international understanding regarding the meaning of the human life, about the meaning of human dignity and the protection of the human life and the human dignity. So I think we have to enforce our lessons in terms of what is coherent for the international community. Because if it's not legitimate that somebody can act violently against one people, of course, should not be legitimate that the violence could be observed and taken for granted against another people. So we shall be coherent.
Indeed, and that is the need of the hour. So from dual technology now, we would move our focus to the era of artificial intelligence. How do you envision the future of human rights and minority rights in the era of artificial intelligence and machine learning, which often rely on the dual use technology? So they are interconnected in terms of their reliance.
I think that despite being minority or not part of minority, all people in our societies shall be granted the same level of access to knowledge, to the civilization in this context of the industrial revolution, of the fifth industrial revolution. I think that we just a step ahead of the Internet of Things. And of course, here in Brazil, unfortunately, we have at this time in our common history different populations, different students in different states that they don't have access to the internet. So what is the meaning of this? What is the practical meaning of it? It is generations which are not at the same pace of human development in terms of technology access, in terms of knowledge itself, in terms of science. So we have to overcome these inequalities, these disparities. So I think, Furqan, that the very first and urgent point in our social agenda is to grant equal access to the civilizational process of the overall meaning of human dignity, which is to fight against the hungry, to fight against the population in streets, to give them opportunities to be part, to engage socially speaking in every and each area in our society. So we have to do much work because so far the modernity has not accomplished it with all their promises for all of us, because the 18th century thought promised us that we shall be free, that all the actions of human men would be derived from our own doing, that we should not put our faith in the gods, because the human being would be the God to himself. And so far, these promises, they were not accomplished for all of us. Technology has not fulfilled our needs. In different levels in our society, technology has done actually the opposite. It has created a profound level of inequality. And we have to overcome those social challenges.
Indeed. Moving on to our last question, which would be, which would be based on your suggestions and recommendations. So, what measures do you suggest for promoting reasonable use of dual-use technology in a way that respects and enhances human rights and minority rights?
Well, I think I have shared some ideas about that topic, and I will turn on the point that I think that we, as law professors, as researchers, as references in our own societies, because we have the opportunity to speak, but also I quote your own words like 2 months ago when we had another meeting, and I quote your own words that in Brazil you spoke to our students and colleagues, and you said, I quote your words, your own words, that you were giving voices for the voiceless people. You remember that? So I think that our very first commitment shall that not only we can give them voice, the voice to the voiceless, but we can fight, we can manage to be in those social places and institutional positions that we can enforce the commitments for democracy with democratic experience. Because I have learned so far in 52 years of in my age, thanks the Lord, that democracy is experience. Democracy are made by moments that you feel yourself respected, and at the same time that you can express respectfulness related to the other, related to your equal. I think that's our first commitment. The second one is that we shall constrain our institutions to never forget the very commitment with the perception and understanding of fundamental rights. So we cannot forget that all of us, we are obliged by the principle of the rule of law. And what is the meaning of the rule of law? And what is the meaning of democracy and human dignity for us? So put yourself in that place. I should that we enforce the empathy related to the other, to the other with whom we are sharing the same place in this moment in our history. I think that's it's not easy, it's complicated, it's challengeable, but I think we cannot hinder ourselves from this commitment. I think that's the point.
Thank you very much indeed. Any last message or any, you know, a slogan would you like to,
Well,
express to our audience?
I'd like to share that to live is not easy. Not give up. Never give up. Because every day we have our challenges. And it's very important that we understand that alone by ourselves, we are not able to achieve collective goals. Only acting collectively, we can overcome our common challenge, and somehow we can balance the strings of power in order that tomorrow you yourself can be protected against your own actions. This is very about the idea of Michael Walzer. We have to exercise tolerance, understanding that the one who most needs it is not the other. It's me and it's you. We need tolerance more than any other people around you. Many thanks, Furqan. I'm very happy to have this talking with you, and I present my excuses if I somehow could not accomplish with your expectations. Many thanks.
Oh no, Professor Cassius, you've been very brilliant. You actually enthralled me with your profound knowledge on the subject. You have, as you've touched upon the influence of dual-use technology, you have also provided us the difference between positive and negative purposes in relation to human rights and minority rights. When we talk about dual-use technology, you also provided us difference between the security and privacy to be that can be maintained in the context of dual-use technology. You have given us the role of the examples of the role of international community, including organizations like UN. You have given us your, future visions. You've talked about Internet of Things. You have given us your profound message, to maintain human dignity. And thank you so much once again for your time and providing your valuable insight to our audience. It's been wonderful having you. I'm constrained by our time limitations. Otherwise, this can go for a long, long way. I can carry on with you for at least an hour because uh, I would take it and I would consider it as one of the most informative podcasts or the webinars that I've ever conducted. So thank you so very much indeed.